Copyright infringement in the digital age has become increasingly common, and the Digital Millennium Copyright Act provides a powerful tool for content creators to protect their work. Understanding how DMCA claims work is essential for both copyright holders and website owners. A DMCA claim, also known as a DMCA takedown notice, is a legal request for the removal of copyrighted material that has been used without authorization. Enacted in 1998, the DMCA implemented treaties signed by the World Intellectual Property Organization to protect copyrighted content across all digital mediums. The law establishes that while internet service providers are not directly liable for displaying infringing content, they must remove such material from their users' websites upon receiving a proper notice. Importantly, your copyright does not need to be registered with the U.S. Copyright Office to take advantage of this protection. Unfortunately, the DMCA takedown process is sometimes misused for censorship or unfair competition. Some individuals or companies file false claims to suppress criticism, silence negative reviews, or target competitors' content. To balance this potential for abuse, the DMCA provides a counter-notice process that allows alleged infringers to challenge claims and restore content when appropriate. If you discover someone using your copyrighted works without permission, you should immediately file a valid DMCA claim. Your notice must include several key elements to be considered valid. These include your physical or electronic signature, identification of the copyrighted work being infringed, the specific location of the infringing material, your contact information, and statements affirming your good faith belief that the use is unauthorized and that the information in your notice is accurate. Before sending a takedown notice, verify that you own the copyright or have the right to assert infringement. Ensure the supposed infringement is not covered by fair use or free speech protections, and confirm the content is in a digital form capable of being infringed online. When filing a DMCA claim, you must first locate the right person to contact. This might be challenging as there is no consistent location for this information on websites. Look for copyright information or check the terms and conditions. Many large websites and search engines provide specific online forms for DMCA takedown requests, which typically result in faster responses. If no form is available, send your notice to the designated DMCA agent exactly as they request, whether by email, fax, or registered mail. Several common mistakes can lead to rejection of your DMCA claim. These include failing to prove ownership of the copyrighted material, not including all required information such as specific URLs, targeting content that qualifies as fair use, and not considering jurisdiction, since the DMCA primarily applies to US-based hosting providers. If you receive a DMCA takedown notice regarding your content, your hosting service will typically remove the material in question without judging whether it actually infringes copyright. The DMCA requires service providers to notify you immediately when they remove your content, and you have the right to submit a counter notice requesting restoration. While there is no time limit for submitting a counter notice, responding promptly is advisable. If you send a counter notice, your service provider must replace the disputed content unless the complaining party sues you within 14 business days. Before sending a counter notice, carefully consider whether you might be infringing on the other party's copyright. The counter notice requires that you have a good faith belief that your material was wrongly taken down. If you send a counter notice and the complaining party has a strong case for infringement, you could trigger a lawsuit. To be effective, your counter notice must include your signature, name, address, contact information, identification of the removed material and its previous location, a statement under penalty of perjury that the material was removed by mistake, and your consent to the jurisdiction of a federal court. The DMCA provides safe harbor provisions for online service providers that can shield them from liability for copyright infringements made by users. To qualify for these protections, website owners must establish effective notice and takedown procedures, designate a copyright agent registered with the U.S. Copyright Office, and communicate their copyright infringement policy to users. Website owners and content creators can take proactive steps to reduce the risk of copyright claims. Always use licensed content or obtain proper permissions for images, music, or videos. Understand fair use limitations and create original content whenever possible. Provide proper attributions when required and monitor your content for potential copyright issues. Remember that not all cease and desist letters are DMCA takedown notices. The DMCA safe harbor provisions only apply to copyright infringement, not to trademark infringement, defamation, or trade secret claims. Always read any legal notices carefully to determine the appropriate response. Filing a false DMCA claim can lead to serious consequences, including perjury charges and potential lawsuits. The DMCA is primarily a U.S. law, but many international websites comply with DMCA requests if they host content on U.S.-based servers or work with companies under U.S. jurisdiction. Understanding the DMCA claim process is essential for protecting your creative work and responding appropriately to takedown notices. Whether you're a content creator seeking to defend your copyright or a website owner navigating a takedown request, knowing your rights and responsibilities under the DMCA can help you avoid legal complications and protect your digital presence.